So my name is Emily Kile, and I am thrilled to have you all as part of our presentation today. The last few webinars I've been doing, we've invited other speakers, so I haven't had to do very much, but today it's all me. Again, there's the chat box and the Q&A, so if you have questions, please let me know, or you can always call the office afterwards, and I'll do my best to get your questions answered. So we have a lot to review today. So these are the 4 topics that I think are super important as your kids with special needs turn 18 or are getting close to age 18. So we're going to talk about guardianships. We're going to talk about special needs trusts, ABLE accounts, and SSI benefits. There are a whole host of other things that you obviously are going to need to worry about as your kids turn 18 or graduate from high school, related to education and vocational training and trying to figure out what the next plan is. I think probably one of the hardest things for a parent is that you lose so much structure after high school for the kids who are not going to move on to community college or continue with a job that maybe they had while they were in high school. And I imagine that that is incredibly stressful to think about what happens. Am I falling off the cliff? There are lots of resources in town. I hope that you'll reach out to those nonprofits in town that can help you through those difficult transitions. These are the 4 legal topics that I like to focus on for parents as your kids reach age 18 or get close. The other thing is, if you want the PowerPoint, just email Sarah, who sent out the invitation in the first place. We're more than happy to email it to you so that you can have it for future reference. So let's talk about guardianship. I think that's probably one of the largest topics that parents struggle with in terms of, do I need to file for guardianship? When do I file for guardianship? What does it mean? You know, what are all the people that are going to become involved in my life as a result of the guardianship? And it feels super overwhelming. So to kind of break it down, guardianship is that court action so that you can continue to make the same decisions you've been making for your person, your child, when they were not 18 years old yet. So guardianship is really about health and housing decisions and not about financial decisions. So that includes making sure you can continue to go to the doctor with your child. You can review medical records. You can decide about surgeries and treatments. And guardianship takes those choices away from your child. You're always supposed to strive to do what you can to increase their independence, help them to make decisions, help them to understand why you're making those decisions, listen to what their goals are, but you remain a parent if you are approved for the guardianship. So guardianship rules are the same once the child turns 18 as they are for the 90-year-old who might have Alzheimer's or dementia or had a stroke. So it can be somebody who has a developmental disability, mental illness, use of drugs or alcohol, physical disabilities, if they make it such that that person cannot make their own health and housing decisions. So it's a continuum, right? So we have lots of folks who probably can make those decisions even though they might have a diagnosis that is a developmental disability or something else. And we have folks who it's clear need a guardian. But lots of people are in the middle, and I think that that is a hard decision, and you need to consult with your physician about what they think in terms of that person's ability to make those health and housing decisions going forward if you were not there to make it for them. So you can file the guardianship up to 6 months prior to the 18th birthday for the individual, and it becomes effective on their 18th birthday because until then, as the parent, you are the de facto guardian. You have the right to make all of those health and housing decisions. So the concern becomes once that individual turns 18, they're an adult in the eyes of the law. They can make their own decisions, whether they're good decisions or bad decisions. They get to make all of those choices for themselves. So the joy of being able to file before they hit age 18 is that you won't have that gap in time. For lots of parents that I talk to, Their kids are very cooperative and they're not concerned that they're going to run into any roadblocks, but having it in place means we don't have that risk at all. So if you were traveling and you hadn't filed yet and the child is 18 and now you have to see a doctor or a hospitalization and they're not familiar with you, you clearly would want to make sure that that guardianship was in place. Now, lots of parents call terrified that they missed that 6-month window and they feel like they can't file for guardianship anymore because it's now the child is 18 or it's 3 months before the child's 18th birthday. As I said, an adult guardianship that's up to 6 months prior to age 18 or forever till they pass away, the rules are exactly the same. So you can file for guardianship up to 6 months before. You can file for guardianship when they're 20, when they're 25, when they're 50, whatever you think is important. For some of the kids, they may have a developmental disability that will impair their decision making and it will get worse over time. So maybe they don't need a guardianship when they're 18, but maybe when they're 25 or 30, that guardianship needs to be in place. And you can file at that point too. So you haven't lost out if you miss the 6-month window beforehand. It's just to give parents some breathing room so they don't have to wait till age 18 and then have the guardianship go in place. Because typically it's about 4 to 6 weeks before we have a hearing date and you get appointed. And so there could be a gap in time if you wait and that child has already turned 18 by the time we get to court. So guardianship is a big deal. There is a lot of paperwork to do. If you decide to do it on your own, just remember, don't miss a step. So all of the steps in the self-service packet that tell you what the instructions are, every single one of those steps has to be followed. When it says that you need this many copies of the documents, when they need to be delivered, what your time frames are, those are hard and fast. You must follow them or you might end up in front of the judge and you don't have your paperwork in order and the hearing can't go forward by statute. The guardian is going to have to do some testimony, although in these uncontested matters, assuming that your child isn't going to object or that your ex-spouse isn't going to object to you being appointed. They are very straightforward, but you will have to raise your right hand and tell the truth, the whole truth, and nothing but the truth. Other than that, it's not really like TV. There will be a court investigator who's going to have a conversation with you and the person who needs the guardian so that they understand what's going on. I'll go into that in a little more detail in a moment. And again, the person who we're deeming incapacitated has an absolute right to object. So they can get to the hearing and object, even if they told you the day before they weren't going to object. They have a right to say they don't need a guardian. They have a right to say they don't want you to be the guardian. Other people can object. As I said, the other biological parent or adoptive parent can object. So if you're not on the same page, you might want to have that conversation before you file so you know what to expect. And maybe there's another relative who thinks that they're the right person to be the guardian. So it can turn into quite a contested matter. My hope is that your family dynamics are such that that wouldn't happen. And there will be a live hearing. When I say live, I mean virtually live. So we don't go into the courtroom these days, but there absolutely will be a hearing. I understand in some states, everything is done by paper. So you submit the papers, you get appointed, and that's the end. But in Arizona, we're required to have a live hearing in front of a commissioner or a judge before the guardianship will happen. People are often afraid of filing the guardianship because they want their loved one to retain the right to drive and to vote. At least those are the most common rights that people would like to retain. You can be a guardian and your child or other person can retain their right to vote and to drive so long as the doctor who submits the report specifically says that the person has the capacity to make those decisions, and therefore they feel confident that the person will be able to either get a driver's license or be a safe driver and understand and cognitively be able to make decisions. Now, sometimes that's a rub, right? So if you're saying that your person can make snap decisions in a stressful situation driving down the highway, but they can't decide whether or not they should take penicillin for their strep throat, that may be a rub for the court in terms of how do they have this ability, which is a pretty high level of cognitive thought, and not another. The same to vote, but we certainly have gotten those things approved. And particularly if somebody's had a driver's license, they've been a safe driver, there haven't been any accidents or citations. And basically what they use the vehicle for is for short distances to go to work. So it's possible, but I will tell you, we want to make sure we have good evidence from the doctor before we go to court to make sure we can present a decent case on that. So I started by telling you it's a lot of paperwork, and it is a lot of paperwork. And everything has to be in paper right now. Eventually, we'll be part of the e-court system, and we'll be able to electronically file documents. But right now, everything is paper and pen. And so this is sort of a general list of the documents that are needed to start the action, what has to be filed before you have your hearing, and things that have to be provided to the commissioner or judge at least 5 days before your hearing. It's a lot. If you do it on your own, again, just make sure you're following the instructions for the self-service center. Follow all of the instructions. And of course, if you hire an attorney, such as our office, to help you, we take care of making sure all of the documents are completed appropriately, that everything is done in the right time frame, and everybody who's required to have notice will have notice. That is also a very important point. So a parent is required to be given personal service of the documents, as is the person that we are applying for the guardianship for. So if you are divorced or there is a other parent of that child, we have to give them notice unless we can show that that is a danger to you or to the child. So if you have an order of protection, for example, and we're not to release your address, we can often get an exception to that requirement. But everybody who needs to know has to know, and the statute tells us who has to get notice of the proceedings. So there's a priority for appointment, but the court can skip somebody who has priority if they feel that they're not the right person to be the guardian. So clearly, if you're married, your spouse would have priority, a parent, an adult child, the caregiver who knows you the best or knows that individual the best. But again, we can skip over that priority. We can get consents from relatives who may have higher priority. So we can figure out who the right person is. And if the family agrees, as I said, we can get consents from other folks. This often comes up when we have divorced parents or another biological or adoptive parent, and they're perfectly fine with letting one parent make the decisions and then they can consent. Also, when we have maybe it's a person, maybe over a brother or a sister, and we need all of the siblings to be on the same page. There's an affidavit that has to be filed to show whether or not there's any history of violence, abuse, neglect. And so obviously, well, maybe it's not obvious, but most likely if there's a past history with the Department of Child Safety and it's recent against this person that you're trying to be guardian of, the court's going to have some serious concerns about that. So I've kind of harped on the parents, but they do have equal priority. And so if they can't agree, the court might appoint a third party to be the guardian, or they might say you're going to be co-guardians and you're going to have to make decisions together. We have lots of divorced parents who get along fabulously well for the benefit of their special needs child, and it's always heartwarming to see them put the child in front of whatever feelings they have about each other. So clearly that can absolutely happen. So these are the people I was sort of telling you will become a part of your life. We have to have a physician or a nurse practitioner who provides a medical review, a medical report for the court, so they understand diagnosis, medications, where the person should live, and whether in fact the guardianship is needed. And as we talked about, voting rights, and driving privileges. The court will appoint an attorney for your person, your child. They are appointed by the court. We don't get to pick them. And they will talk individually, usually now by FaceTime or Zoom or over the phone with your kiddo if your kid can communicate in such a way. And they'll probably have a short conversation with you as well. There's a court investigator. Those folks are court staff, and they're most of the time social workers, and they'll want to talk to you, and they're also going to want to talk to the person who may need the guardian. They like to do those now by FaceTime or Zoom so they can sort of see where the person's living, get some eyes on them to see that they're safe and well cared for. They, of course, used to visit in person, but those are all being done virtually or over the phone now. And then, of course, we have you as the overwhelmed proposed guardian. And the court investigator will provide a report to the court, usually just a couple pages of a summary of what they see and whether they support or do not support the petition. The hearing will be set, as I said, about 4 to 6 weeks from the date that you file your documents, so there'll be a little bit of a time lag. The hearings are all being done on either GoToMeeting or Court Connect, and so the judicial staff will send a link before the hearing, usually about 3 to 5 days in advance, with the link for you to use, so you don't have to guess which platform you're on. But we don't do live hearings right now, and I don't think we probably will for these uncontested matters. There's no reason for everybody to have to drive to court when we can do these virtually. Also, if you ever want to practice beforehand, there is both a video that we're happy to send you from the court, or you can find it on the court's website, and we're happy to practice with you to make sure you know how to use the platforms. But they allow you to talk and hear the other hearings that are going on, the court can ask you questions, and if everybody has a camera, everybody can see each other. There is a mandatory training, which even if your kid is not close yet, I would recommend that you watch. They're really good trainings. They were put together by court staff, and they kind of go through your responsibilities and sort of what to expect. So that's the link for where you can find them. And again, I think they're just useful, but you have to file your certificates of completion before your letters of appointment, which are the papers you get that show you're the guardian, before you can have those issued by the court. So again, if you have to have a physician report. If your kid doesn't have any money other than Social Security benefits or maybe a part-time job, you can ask for the fees and costs to be waived, and it'll save you about $800. You need to make sure you do that when you file your initial petition and not after the fact. And also at the hearing, you can ask for the court-appointed attorney's fees to also be waived. Guardians have all the rights to make all decisions for the person. We call them a ward of the incapacitated person, including to consent to marriage or adoptions. Guardians can manage up to $10,000 a year in assets. So usually Social Security is going to be under that amount. So if they just have SSI benefits, you're already the rep payee, probably don't need to file anything else with the court. You can also be a trustee of a special needs trust, and typically you are not going to need court approval for that if it's the kind of trust that's part of an estate plan. So no reason to file for conservatorship unless you actually have to manage assets. If you're going to move outside the state of Arizona, or the incapacitated person is going to move outside the state of Arizona, we need to transfer that guardianship, which should be a fairly straightforward process if they're part of the Uniform Act, which most of them are. But we do need to file something here to say we're transferring this out of the state, and then once it's accepted in the other state, to terminate the local guardianship. Guardianships, even though we call them permanent, don't have to be. So if you want to terminate it because the incapacity is no longer there, we can submit a request to the court. You can resign as the trustee. We just have to file with the court, and they can appoint somebody else or decide that no more guardianship is needed. One of the things that I know parents struggle with is, do I need guardianship, or is a healthcare power of attorney sufficient? So remember, guardianship is a court action. It can only be terminated by the court. a healthcare power of attorney, your child can revoke that anytime that they want to. They can say, I don't want you anymore. I want this other person to be my healthcare agent. And they can still say they don't want you to get medical information. You become somebody who can help, but they can, as I said, say, no, I don't want them to get my medical information, and I don't want you, doctor, to be talking to them. And as I said, it's expensive. You can get, though, that about $700 to $800 in fees waived, plus court-appointed attorney costs waived, and certified letters and order costs waived, which I think are about $30 each. But just make sure you ask for that at the very beginning of the case. So we're going to go to our next topic, which are special needs trusts, but I did see that we had a couple of questions. So let me just see what they are. Is the guardian a sole individual, or can it be parents? Can there be a hierarchy of guardians in the event of death of the guardian? Excellent question. So the answer is both parents can be co-guardians. If you have another adult child, you can all three be guardians, but we don't have backup guardians. So if you are named as a guardian, you have the same rights as every other guardian. You can name a backup guardian in your estate planning documents. You can do a separate nomination of guardian form, or you can put that information in your will. And when you pass away, if there isn't a living co-guardian, then that person who's nominated would either file the will in or that nomination form with a couple of other documents. They would be appointed right away, and then we would go back and have all of the court hearings. So that's an excellent question. Thank you for asking it. Another question is, what happens if you file after your child is already 18 and the child disagrees or objects to the guardianship in court? Obviously, just a hypothetical, because all of your kids would say yes to whatever you thought was in their best interests. So whether you file before age 18 or after age 18, the child has a right to object. They would tell their court-appointed counsel they either don't think they need the guardianship at all, or they don't want you. And so if it's just they don't want you, but there's somebody else that's okay with you to be the guardian, then that person can be the petitioner, or that person can be nominated by you. If they don't agree to the guardianship at all, they need to provide medical evidence that is clear that they are not incapacitated and they do not need a guardian. So they don't just win and there's no guardian because they object. They still have to provide enough evidence, as do you, in order to have the guardianship not be obtained. So there's hope yet, even if they object. And another question is, why is it a big mistake to be conservator? So it isn't a big mistake to be the conservator, but if you only need guardianship, there's no reason to file for conservatorship, which is to manage assets of more than $10,000. So if your person you want to be guardian over doesn't have any money or assets, the court most likely will just deny the conservatorship because there's no reason for it. If you need to be conservator because you need to manage money for that person, you should absolutely file. There are oftentimes restrictions that are put in place on those assets in terms of being able to access them without a bond. A bond is an insurance policy over you to make sure you don't misuse the money. And you have to provide annual accountings for that, how the funds are used each and every year to the court, which then gets reviewed. You'll have to pull a credit report for the person. And so they're do a budget for each year. It's a big deal to be conservator. So I was only suggesting that if you don't need to manage any money or assets, there would be no reason to file for conservatorship. But if you do, you absolutely should. That is what it's there for. So I didn't see any other questions on the guardianship. So I'm going to move to special needs trusts. Okay, another deep breath. So the purpose of a special needs trust is to allow a beneficiary of SSI, supplemental security income, and or All-Tax DDD benefits to maintain those benefits, but still have money available for taking care of all of the things that those government benefits do not assist with. Remember, when there's $1 of assets in a special needs trust, it must be reported to the agencies that are providing services or money. So even though your lawyer drafted it and it's a fantastic trust, because the agencies are providing benefits, they have the right to say whether it meets the criteria or it does not meet the criteria. Typically, your special needs trust is going to have a provision that allows you to amend it in the event that the agency says there's a problem with it, so that the trust will still work and they'll still maintain their benefits. But that is the purpose. And there are lots of different kinds of special needs trusts that we're going to talk about, but I've often had people be concerned that if they put money in a special needs trust, that they could not be used for anything for the beneficiary. And the whole point is to have that fund to cover all the things that the government agencies do not cover. And I want to make sure that people understand SSI is supplemental security income, not disability benefits. So this is for somebody, which we're going to talk about as one of our topics, but somebody who is disabled, didn't work enough quarters to get Social Security disability, has low or no income, but is disabled and unable to work. The hallmark of a special needs trust is that the trustee is the one who has sole discretion about when distributions are made, how much, and for what purpose. So whether they're going to buy a car with the money from the special needs trust, is it a Maserati? Is it some other car? Is it a Ford truck? That's a decision for the trustee to make as to what they think is within the budget and makes sense for that beneficiary's needs. The beneficiary can yell and scream and make demands, but only the trustee makes a determination about whether or not to distribute funds from the trust. So it is a loss of control that the beneficiary does not just have an ATM card where they can just get money anytime they want. Having said that, the trustee could put money on a prepaid debit card that doesn't have any ability to take cash out of it. We often use something called a True Link card for that purpose, because you can limit where it can be used and to say that no cash can come out of that, off of that card. So the beneficiary could have one of those cards so they could get their hair cut, they could go out for a meal, they could go to the movies. But for larger purposes, for larger purchases, the trustee would control those. So in terms of maybe to buy the phone or the computer or to pay the rent is going to go directly to the landlord instead of having it pass through the beneficiary. Because remember, if the beneficiary gets the money, that's income to the beneficiary, which will impact their Altex DDD services as well as SSI. So we all know that the public benefit programs are just there to provide the absolute necessities. And so again, this is a way to have money so that we can supplement the government assistance. That might mean that your loved one is living in a group home and they have to share a room under the DDD rules, but maybe they have a special needs trust and they could be in a private room, or they could get an extra caregiver for themselves to bring them out for outings or to help them get more attention while they're in that placement. So that's what the goal is for the special needs trust. So I don't want to get too deep in the legal weeds here, but it's really important to understand the difference between a first-party special needs trust, and I wish we had different words, and an estate planning special needs trust. Because they have different rules and some of the rules scare people. So I want you to understand very much the difference between, again, a first party special needs trust and what I call an estate planning special needs trust. So a first party special needs trust is a trust that's funded with the money or assets of the disabled beneficiary. So most often this comes up when somebody leaves money outright to a beneficiary. So let's say that grandma in her estate planning documents said that she left $20,000 to Joey and Joey gets Altex benefits. Well, now Joey's got $20,000 and he can't have more than $2,000. That might be the time that we need to create this first party special needs trust to move Joey's money that he received directly into a trust, a special needs trust, so that he can maintain his benefits, but the trustee can manage those assets for him in the trust. Also, it comes up when we have beneficiaries who are injured. So maybe we had a beneficiary who had autism and then they were out on a bike ride and they got hit by a vehicle and now they've received money from a personal injury settlement. Or maybe we have a beneficiary who didn't have a disability but got hit by a vehicle, now receives money but needs to be on all-tax long-term care benefits or SSI. Those kinds of funds also should go or could go into a first-party special needs trust. These are what we think of as the payback trusts. So these are the trusts that say when the beneficiary dies, and only when they die, does the state have a right to collect money that's still in the trust up to the amount that the state Medicaid agency paid for care. So if there's $1 million in the trust and the person received it from a personal injury settlement and 3 months later they pass away, most likely there's not $1 million that's going to have to go back to the state, but the state gets the money first. So I always say and recommend that if there's money in a first party special needs trust, you want to pay for things like the mortuary or the cemetery first, the burial or cremation, because literally when the beneficiary dies, you cannot touch that money until Alltex says, we're good now, this is how much you owe us, or you don't owe us anything, now you can have access to the money. So making sure those things are paid in advance. We also have things called pooled special needs trusts, pooled first party and kind of estate planning third party trusts. One of the webinars we did was with a trustee from a pooled special needs trust. So this is where they work similar to the first party special needs trust, but we have a professional trustee who's managing it, and they are all nonprofits who act as trustees for these kinds of trusts. First party special needs trusts have some very specific criteria. They can only be created and funded when the beneficiary is under the age of 65. So if we have a beneficiary, which is probably not our audience because you guys are have kids maybe that are getting close to age 18, but we have an older person who's injured and they're 70, we can't put the money in a first party special needs trust in order for them to maintain their Alltex long-term care benefits. Has to be funded prior to age 65. Obviously, the assets of the disabled individual, and that person is the sole beneficiary. It can't be used for other beneficiaries. They can't gift the money. All the money has to be used only for that beneficiary. And there is only a limit on who can create the trust. So our competent disabled beneficiary, a parent, a grandparent, the guardian, or the court. Nobody else can create one of these first party special needs trusts. I can't do it as an aunt to my niece who has Down syndrome. I can for estate planning trust, which we're going to talk about next, but not where it automatically becomes the money of the disabled person. And as I said, we have to include the language about the reimbursement when the beneficiary passes away. So then we have these third-party special needs trusts. This is your estate planning opportunity. This is the trust that you can draft with your attorney that says, hey, when I pass away, this money is going to go to this beneficiary who's disabled, but when they pass away, I want it to go to the rest of my kids, or to charity, or my nieces and nephews, or my brothers and sisters. There's no Medicaid payback for these third-party, what I like to think of as estate planning special needs trusts. And anybody can create this. So I could create a special needs trust for my niece with Down syndrome, and her parents could have their will say, well, the assets go into that special needs trust. Anybody can add money to that trust, except for the beneficiary. And as I said, we can say whoever we want to be the final takers, the final beneficiaries, once the main beneficiary has passed away. You can limit how the money is used or not. And most of the time we want it to be broad and totally discretionary on the trustee so that the trustee can buy things for that beneficiary as they need them. Same issues with giving the beneficiary money directly. That's still income to the beneficiary. So we would want to limit that as much as possible. Distributions from our first party special needs trusts are limited by law. So there's a list of about 11 things in the statute. They're pretty much anything, the things you would want to be use the money for, but it's very specific. We have to provide a budget in advance to Altex if the beneficiary is receiving Altex benefits. Third-party special needs trusts, we don't have that same list. We're not limited by what the statute says. And you can have one trust for a whole bunch of disabled beneficiaries. So if you have 2 children who are disabled and on benefits, you can have one special needs trust for both of those kids if that's what you wanted to do. Special needs trust can be created as part of your will. They can be a standalone document, which is my preference because we do have to provide a copy of the document to the agencies. It can be a subtrust of your trust. So lots of ways to create them and make them work, but they're very important to complete while you're still living so that other people can say they want to put money in and we don't end up in that first party situation where we're going to end up with that payback. The trustee, of course, is the person who manages the money. You want to make sure you're going to have a beneficiary who's going to outlive your kid, right? So you don't want to name all older people and your child is 5. So sometimes it's important to maybe have a corporate entity in case all of the other individuals fail. Or maybe you want to have 2 or 3 individuals who could pick a licensed fiduciary or another individual who's young enough so that they can act as the trustee. We want to separate the money, so we need to make sure the right money goes to a first party trust and the right money goes into that third party trust. And as I stated, you must report the trust once there's $1 of money in it, regardless of whether the funds came from a third party or a first party. Both of those trusts need to be reported once there's any money in the account in that trust account. And there are a bunch of other reporting you need to do if the person is receiving SSI benefits, which we will get to later. Here's kind of a list of what I think are some useful resources to help people. They're all nonprofits and can help, well, except for Social Security. I suppose that's not a nonprofit, a federal agency, but the rest are super helpful in terms of finding information. Special Needs Alliance is a group of attorneys across the country who do special needs work, has great articles called The Voice, and you can go on their website and see a lot of terrific resources. So, and Raising Special Kids, of course, is a local nonprofit here. So I would encourage you to check those out. So before I go to the next topic, which is going to be the ABLE accounts, let's see if we have any questions associated with our special needs trusts. So I don't see any new questions. So I must have been perfectly clear on our special needs trusts, which again, you should absolutely have as part of your estate planning. So with that, then we're going to move on to ABLE accounts. So ABLE stands for Achieving a Better Life Experience. And ABLE was started in 2014, although it took a little bit of time for regulations to be created and for Arizona to adopt their regulations so that we could have a program here. The ABLE accounts were started as a way to make sure that kids who are on SSI and long-term Medicaid benefits could still save money, right? We want to teach our kids saving money is a good thing. But if you can't have more than $2,000, you're constantly trying to figure out how do I spend the money, so we keep them below that $2,000 limit. And this is a way that you can go above the $2,000 limit. I've given you the website for the ABLE accounts. It's a fantastic website. I think their frequently asked questions section is great. It's free to look. It's free to set up an account. The minimum balance is $50, I believe. And so you can set up the account with 50 bucks and it doesn't cost anything. So I would definitely encourage you to go to the az-able.com website and take a look around if you're not familiar with ABLE accounts at this point. So a couple of criteria. The first is that the person has to have been deemed disabled prior to age 26. So even if they're not getting all-tax benefits, if they've been approved for DDD, they would be considered to be disabled, approved for SSI. And if not, you can get a certification from your doctor that they're disabled, although I wouldn't see any reason to set up an ABLE account unless they're receiving benefits and the goal is to keep them below that $2,000 limit. You can set the account up in any state that's passed legislation and that would allow you to. So some states like Florida, you have to be a resident of the state in order to be able to set up an account there. Arizona is the same way. I would encourage you to use Arizona because it was set up locally and so our all-tax office is familiar with it, but you don't have to. Only one ABLE account per beneficiary. So grandma can't set up an account and then mom set up an account and then dad set up an account. You get one per beneficiary and contributions can be up to $15,000 in a calendar year. That's to go along with the gift tax exclusion. So whatever that amount is per year, that's how much can go into an ABLE account in a calendar year. We think of gift tax exclusion as it's $15,000 per person. So I could give $15,000 to my niece, my nephew, my uncle, whomever I wanted. For this purpose, it's a total of $15,000 into the account for that beneficiary. Kind of works like a first-party special needs trust in that once the beneficiary passes away, we can do some administrative costs and funeral expenses, which you cannot do out of a first-party special needs trust. But what's left in the account goes back to the state Medicaid program, our all-tax program, up to the amount that was paid for care. If the account grows and exceeds $100,000, their SSI benefits will be temporarily suspended and their all-tax benefits will remain in place. They are not impacted by that $100,000. But you do want to be conscientious because it can be invested and so you might end up with some growth that puts you over that $100,000 limit, although it'll take some time to get there at $15,000 a year. Again, the money in the account is not counted for SSI or all-tax, either as income or as an asset. The money, as long as it comes out and is not cash to the beneficiary, is not income to the beneficiary. So if the money is used to buy things, it's not counted as income in the month that it comes out of the account. The money grows tax-free, kind of like a 529 college savings plan. So it is invested and grows tax-free and comes out tax-free as long as it's used for the beneficiary. But there is no brick and mortar bank to go to. You have to set it up online, either at azable.com or one of the other ABLE accounts in the other states. So this is how I think ABLE is super useful. You know, if somebody gives them too much money for you to spend down in that month, you can put it in an ABLE account if you haven't matched the $15,000 yet. Kind of a way to help a beneficiary learn how to manage money if you wanted to put some money in there, and then you can get a prepaid debit card from the ABLE account as well, so that they would have their own walking around money and learn, you know, when the debit card's empty, there's no money left. Again, small personal injury settlements or inheritance where we're not going to be able to spend them down to $2,000, and so we want to be able to save the funds. You can put excess Social Security payments into the account. It's income when it comes to the beneficiary, but then it could be moved over to keep the beneficiary under that $2,000 limit. The same for excess from a job. So if they're accruing too much money, they have more than $2,000 in their personal account, you can move the excess over to the ABLE account. And I also had a beneficiary who did a scratch off and won money from the lottery. And so we put that in that parents put that money in the ABLE account, and that worked really, really well, so that the money was available but didn't put the beneficiary over the limit. So our next topic is going to be SSI, but it looked like I had maybe 1 or 2 questions on this topic. Are there assessments or interviews that your law firm gives to see who may best fit the unique individual? Oh, for trustee. Would you be able to determine that any or none of this is recommended? So we're happy to give you the names of licensed fiduciary companies and banks that often work as trustee and handle special needs trusts, which is, I think, what the question is. More than happy. We're also happy to put together a list of questions you might want to ask the potential trustee, individual or corporate, as to whether they could do this and whether you think they would be a good fit. If my son gets a job, can I have the paychecks deposited to the ABLE account, and are there restrictions on what the money can be used for? So I would still have the paychecks deposited into a separate account because they're income directly to the beneficiary, whether they go directly to ABLE or they go into their own account. So I would have them deposited into an account. It could be a joint account with you. And from there, have the excess funds go over to the ABLE account. So if you're getting close to the end of the month and they're reaching the $2,000 limit, you want to move those funds over into the ABLE account if they're receiving SSI and or DDD all tax benefits. So similar question can be set up as a direct deposit for a job. Again, I would put the money in a separate account and then move it over into the ABLE account. Are ABLE accounts generally managed funds? Is there potential for principal contributions that could be lost? So my understanding in Arizona is that the platform, if you choose to have the money invested, I think it's either Vanguard or Fidelity, that's the back-end investor. You can keep it all in cash. You cannot put stocks in an ABLE account, but once they're in the ABLE account, then they could be invested. And you can choose, I think there's about 4 choices of investment strategies for how you would want the money to be invested. But if you invest it, you're investing it in the market and you have the potential to lose the principal just like any other investor there out in the market. But that's a decision that you can make based on the choices, or you can just leave it in cash. That's not a problem. So I think those are all of our questions that I see, and I don't see any in the chat box, just in the Q&A. So I will move on, and we can always come back to it. We have about, I think, 10 minutes left. So let us move on to what is definitely one of the most complicated, convoluted systems. And I don't know who writes these rules, but I definitely feel like Dorothy as I go down the rabbit hole for SSI. So obviously this is going to be a basic discussion. We have about 10 minutes to talk about it, and we could spend days talking about SSI. But I wanted to first lay out that these are kind of the benefit programs that exist, right? So we have Social Security Disability, which is an entitlement program. So if the person becomes disabled but worked enough quarters, so they paid into the Social Security system, and then they became disabled, we don't look at how much money they have in the bank. We only are concerned about whether they're able to earn money. And so they would qualify for disability if they meet the criteria, again, even if they have $1 million in the bank. 24 months after they get Social Security disability, they're eligible for Medicare. Again, they're entitled to Medicare on the 25th month after getting Social Security disability. For our kids who have developmental disabilities and haven't paid into the system, when they turn 18, they could apply for SSI benefits, because before age 18, the income and assets of you as the parent are deemed eligible to that child. And so if you have more than $2,000, then the child is not going to receive benefits because your income and assets are attributed to the kid because you have an obligation of support. And Medicaid or Access or all tax benefits, the same. You have to meet the criteria, medical eligibility, financial eligibility, both for income and for assets, before you can obtain those benefits for that individual. So There's a lot of text here, but what I want you to understand is that you can get SSI benefits even for somebody who's over 65 who didn't pay enough into the system. Or you can be 18 and you're a kid who hasn't worked and you're disabled. You have Down syndrome, you have autism, you have whatever other diagnosis that the person has that makes it such that they can't be gainfully employed. So we think about all techs and DDD services are because you have a difficult time managing and being able to do your activities of daily living, some cognitive impairment. For SSI benefits, we're looking at, can the person be gainfully employed, which is pretty much thinking, can they have a full-time job even at minimum wage without assistance? So we have some kids who work almost full-time, but they have an aide with them. They get more breaks. They work different shifts. There are all kinds of accommodations for that person. They may still be deemed to be disabled for Social Security benefits and still be eligible. And if they're working, they're also earning credits for disability benefits, which is terrific. So if they can't work in the future, they might be able to get disability benefits, which doesn't have an asset limit and tends to provide more money in benefits. So SSI is a cash payment, unlike All-Tex or DDD, which is services for the person. There are some deductions to SSI if somebody else is providing food and shelter, including if the funds are coming from a special needs trust, or if the child is living with their parent and they don't pay their full ride for the food and shelter expenses. There might be a deduction, but it won't mean that they don't get any SSI unless their SSI is very, very small. So the maximum payment this year, I believe, is $783. Some folks who get some disability and some SSI to get them to the $783. So for most of the kids, because they live at home, they're going to end up with an amount that's closer to $550 because of this deduction, because they're not paying for food and shelter expenses. If they're earning income, they're going to have a deduction from their SSI based on a formula that's used by Social Security. But if you give them cash that they did not earn at their job, it's a dollar for dollar offset after the first $20 in that month. So it matters whether it's earned income or it's not earned income. And they want people to be out there working, so the deductions are less if you're earning income than if somebody is handing you cash. Oh, my little controls are up, making it hard to change my slides. So again, I would suggest you apply after their 18th birthday because your income and assets are deemed available to your child. And you can call and schedule an appointment. All of the offices are still closed. You can only apply online still if you're also applying for disability benefits. You want to make sure you have handy documents about who their treating physicians have been, when they were diagnosed, medications that they're on, and then Social Security can follow up from their database with those doctors to get medical records if it's a disease or a syndrome that doesn't give them automatic qualification for SSI benefits. And they may afterwards ask for your child to undergo some vocational testing by Social Security so they can determine whether that person can in fact be gainfully employed. Remember to disclose all assets. If you have a special needs trust with money in it, you need to tell them about it. There's no money in the trust because it's not going to get funded until you die. You don't have to disclose that because it might not even exist. You might have amended it in some way or decided not to use it at all. But lots of times we get panicked calls from parents because they forget about the savings bonds that were given as a gift when the child was born that have been in the safety deposit box for the last 18 years. That is money, if the child is the beneficiary, that needs to be reported, or you need to make sure you do something like cash it out and put it in the ABLE account before you apply for SSI benefits. And your date of application should be the day that you call to make the appointment. It should relate back to that date as long as they were qualified on that date. So I wouldn't call before age 18. As I said, Social Security will be reduced if food and shelter is paid for by a third party, including you as the parent. So SSI is a great program. It automatically makes us eligible for access benefits for health insurance, even if you only have $1 of SSI. If your child was deemed disabled prior to age 22 and they keep their SSI until the parent retires, becomes disabled, or passes away, at one of those times, retired, disabled, or die, or death of a parent, the child, who might be 50, will become eligible for a percentage of the parent's Social Security, retirement, or disability benefits. That can make a huge difference because the child could go from $783 to $1,000 or $1,200. So they would get 50% of the wage earner's Social Security benefit upon retirement or disability, bumped up to 75% of that insurance amount when the parent dies. And just like Social Security disability benefits, the child will be eligible for Medicare 25 months after they start that disability benefit, sometimes called a disabled child benefit or child disability benefit, CDB or DAC, because we love acronyms. So even if you're thinking, well, they're only going to get $200 a month because they work, what's the point? The point is they keep their access benefits, and if they stay eligible for SSI, they're going to get this fantastic benefit, which doesn't have an asset limit any longer. So if they have money more than $2,000, they're still going to have their Social Security payment. Now, if they're getting All-Tex or DDD benefits, you still need to be under that $2,000 limit. But I find this is a benefit that lots of parents don't know about, and I think it's really important, really crucially important to apply for that SSI if the child might be eligible. So I know it's a lot. Lots of people have gone before you. There are lots of us out there who are happy to help you through figuring out what you need to do and how to get there. So just focus on one thing at a time, ask for help when you need it, find people to be helpful to you. And of course, we're here to help. As I said at the beginning, this is our contact information, so we hope to hear from you. I did have a couple of other questions, so if you can all bear with me. Let's see. So what kinds of benefits would a disabled child be eligible for if they're over 18 and have a deceased parent? So if the parent died prior to age 18, they would have been eligible for a Social Security benefit until the child turned 18. Or if the child's still in school, I believe it would go for another 2 years. If the parent is deceased and you have a disabled child, as I said, I would apply for that disabled adult child benefit with Social Security, which should be a payment where they should be able to get some benefits as a result of the fact that they have now not a wage earning parent. And I should have said that if the first wage earner to retire is the lower wage earner, the child can get some of that Social Security without reducing the parent's Social Security. And when the higher wage earner parent retires, the child can bump up to that person's Social Security benefit, again, without reducing the parent's Social Security benefit. So it's a really nice benefit that's out there. Is it recommended to apply for SSI when a child turns 18, even if they have a part-time job? So the answer is that if the child is disabled and cannot work as a full-time employee, not because they're going to school, but because they are not able to work full-time, I would say it would be worth applying for benefits because all they can say is no. So you apply, they might have some vocational rehab training that they want you to go through, and they might be denied. But if you do it on your own, there's no cost to doing the application and seeing what happens. If they're able to be working full-time, though, they are gainfully employed and probably, unless they have a lot of accommodations, are not going to be eligible for benefits. So the next question was that the person's daughter has autism, will turn 18 in December, and that the parent currently receives Social Security disability benefits. And do they have to apply for SSI first? Yes. So apply for the child for SSI benefits, and then hopefully those will be approved, and then they should be able to convert to the disabled adult child benefit and receive some portion of the disability benefit that you are receiving as the parent. I should have said at the beginning, I'm giving general information. I'm not your attorney, even if I really am, for purposes of this webinar. So please make sure that you always get advice based on your particular circumstances and not just on my general statements based on one little tiny sentence of a description of what's happening. So the last question I think we have is, so if they can work but only part-time due to their disability and have lost jobs due to the issue, is Social Security disability what we apply for? So I would say that it depends. You can apply for SSI and Social Security disability online and see whether or not they have enough credits to get the disability benefit. Again, you still have to prove that the person is disabled to the point that they are unable to be gainfully employed, that is, work full-time, basically minimum wage without accommodation. And understand that even if somebody is approved for SSI benefits, there is still a ticket to work program. So they could still work full-time for a limited period of time to try it out. So if it turns out that they can't work on a full-time basis, they would have retained their SSI throughout that whole time period. So for kids who work for a while and then they lose their job because it's too stressful or whatever it is that happens, and they were on a ticket to work program, they're still going to be on SSI. So Social Security wants to encourage folks to have a job, to work at the job, to see if they can be employable rather than staying on Social Security forever. So it's always worth exploring. You can do your Social Security application on your own for just SSI. You would call the number that I had up before, or call the local Social Security office and schedule an appointment. For Social Security disability, you can apply online, or if you're applying for disability, you can apply for SSI at the same time online, but only if you're also applying for disability benefits. Somebody asked about my costs. So you can call the office at any time, and any member of my staff is more than happy to tell you what our hourly rates are, as well as the fees for the work we do on a flat fee basis, which is most of our estate planning work and guardianships. We do those on a flat fee basis, so there are no surprises. You know exactly what you're going to get. So we ran a couple of minutes over, but I cannot thank you all enough for participating today, for giving me the opportunity to give you some education on these very important topics, and for having an interest. And I love the questions, since I missed the opportunity to chat with you all. So I appreciate the questions that people are interested, and I just appreciate you all so much. I hope that you're doing well, and if we can do anything for you, by all means, please give our office a call, and we would always do what we could to help. So I wish you all the best, and we look forward to the opportunity to serve you, and stay well, and we'll see you soon, I hope. Take care. Bye-bye.